very much, Mr Deputy Speaker. I speak to New Clause 1 in my name and that of others of my colleagues. Earlier this year, I met with members of Leicestershire Police Federation who raised concerns about elements of the Data Protection Act 2018, which are imposing unnecessary and burdensome redaction obligations on police forces. I would like to thank the National Police Federation for their tireless campaigning on this issue, in particular Ben Hudson of Suffolk Police and my honourable friend and colleague, the member for Waveney, for all that he's done in this area, as well as for much of the information that I will share today. As I explained at committee stage, Part 3 of the 2018 Act implemented the Law Enforcement Directive and made provision for data processing by competent authorities, including police forces and Crown Prosecution Service, for law enforcement purposes. Although Recital 4 to the Law Enforcement Directive emphasised that the free flow of personal data between competent authorities for the purposes of the prevention, investigation, detection or prosecution of criminal offences should be facilitated while ensuring a high level of protection of personal data. Part 3 of the 2018 Act contains no provision at all to facilitate the free flow of personal data between the police and the CPS. Instead, it imposes burdensome obligations on the police, requiring them to redact personal data from information transferred to the CPS. Those obligations are only delaying and obstructing the expeditious progress of the criminal justice system and were not even mandated by the Law Enforcement Directive. The problem has arisen due to Chapter 2, Part 3 of the 2018 Act, which sets out 6 data protection principles that apply to data processing by competent authorities for law enforcement purposes. Section 35(1) states, the first data protection principle is that the processing of personal data for any of the law enforcement purposes must be lawful and fair. Section 35(2) states, the processing of personal data for any of the law enforcement purposes is lawful only if and to the extent that it is based on law and either A, the data subject has given consent to the processing for that purpose, or B, the processing is necessary for the performance of a task carried out for that purpose by a competent authority. The Police Federation have said that it is very unlikely that Section 35(2)A will apply in this context. They have also said that in the case of Section 35(2)B, the test of whether processing is necessary is exacting, requiring a competent authority to apply its mind to the proportionality of processing specific items of personal data for the particular law enforcement purpose in question. Under Sections 35(3) to 5, where the processing is sensitive processing, an even more rigorous test applies, requiring, among other things, that the processing is strictly necessary for the law enforcement purpose in question. Section 37 goes on to state, the third data protection principle is that the personal data processed for any of the law enforcement purposes must be adequate, relevant, and not excessive in relation to the purpose for which it is processed. For the purposes of the 2018 Act, the CPS and each police force are separate competent authorities and separate data controllers. Therefore, as set out in 34(3), the CPS and each police force must comply with the data protection principles. A transfer of information by a police force to the CPS amounts to the processing of personal data. The tests of necessary and strictly necessary under the first data protection principle and the third data protection principle require a competent authority to identify and consider each and every item of personal data contained within information that is intended to process and to consider whether it is necessary for that item of personal data to be processed in the manner intended. The impact of this is that when preparing a case file for a charging decision from the CPS, the police have to spend huge amounts of time and resources analysing information which has been gathered by investigating officers in order to identify every item of personal data. They then have to decide whether it is necessary, or in many cases strictly necessary, for the CPS to consider each item of personal data when making its charging decision and redact every item of personal data that does not meet that test. The National Police Chiefs Council and the CPS have produced detailed guidance on this redaction process, which emphasises that the 2018 Act is a legal requirement and that the police and CPS do not have any special relationship that negates the need to redact and protect personal information. The combination of the requirements of the guidance and of the Act represents a huge amount of administrative work for police officers, resulting in hours of preparing appropriate redactions. Furthermore, inevitably, such work is carried out by relatively junior officers who have no particular expertise in data protection, and much of it may never be used by the CPS if the matter is not charged or the defendant pleads guilty before trial. Nationally, about 25% of cases that are submitted to the CPS are not charged. A significant proportion of that time and money could have been saved if the redaction of personal data by the police occurred after rather than before a charging decision has been made by the CPS. The burden this is placing on police forces was highlighted in the 2022 Annual Review of Disclosure by the Attorney General's Office, which heard evidence from police that redaction of material for disclosure is placing a significant pressure on resources. It also found that one police force had invested £1 million in a disclosure specialist team solely to deal with redaction. In their report on policing priorities, the Home Affairs Select Committee also stated, the National Police Chiefs Council and the College of Policing said this labour-intensive process ties up police resources for a protracted period of time, meaning investigations take longer and possibly adds to the likelihood of victims withdrawing their support for a case. The College noted that the problem has become worse as digital devices such as phones and laptops have developed over greater storage capacity, meaning there is more for the police and process to redact. Disparities in digital capabilities across the 43 local forces also exacerbate the problem. The report went on to say, lengthy and inefficient redaction processes and protracted investigations are neither effective nor fair on either victims or suspects. The handling of case files needs to comply with data protection laws. However, ensuring that the requirements are proportionate and that forces have the digital capacity to meet such requirements efficiently is an urgent issue that needs addressing. More needs to be done to pilot solutions and get the balance right. Furthermore, the Police Federation and the National Police Chiefs Council estimate that the cost nationally for this redaction exercise is over £5.6 million per annum. There is no disputing that there is a clear issue here, and I welcome that it has been acknowledged by a number of ministers I've been engaging with, including the Minister for Crime, Policing and Fire, my honourable friend, the member for Croydon South, the then Home Secretary, my honourable friend, the member for Fareham, and the Minister for Data and Digital Infrastructure, my honourable friend, the member for Malden, who only last week emphasised to me the government's support for reform. Indeed, the autumn statement last week highlighted the government's commitment to boosting public sector productivity by running an ambitious public sector productivity programme with all departments to reimagine the way public services are delivered. The focus of this is on reducing the amount of time our key frontline workers, including police, doctors and nurses, spend on administrative tasks. This is to ensure that they can spend more time delivering for the public. Arguably, the current process of data redaction is the biggest unnecessary administrative task, keeping police officers away from the front line, so reform needs to be implemented urgently. The amendment I put forward lays out a blueprint for this reform and inserts a proposed new section into the 2018 Act to exempt the police service and the CPS from complying with the first data protection principle, except insofar as that principle requires processing to be fair, or with the third data protection principle when preparing a case file for submission to the CPS for a charging decision, thereby facilitating the free flow of personal data between the police and the CPS. Where the CPS decides to charge, the case file will be returned to the police to carry out the redaction exercise before there is any risk of the file being disclosed to any person or body other than the CPS. In the 25% of cases where the CPS decides not to charge, the unredacted file would simply be deleted by the CPS. My new clause would have no obvious disadvantages, as the security of the personal data would not be compromised and the necessary redactions would still be undertaken once a charging decision has been made. Furthermore, providing material unredacted to the CPS pre-charge will not impact the timeliness of this process in any way, as the police will still be providing the same material to the CPS as they would have done previously, just unredacted. I know from my conversations with ministers that there are a few questions from a number of sources about whether legislative change in this is the best way to tackle the issues surrounding redaction. To that, the police federations have said, the hope is that the CPS will set out within their charging advice what material they intend to rely upon, and therefore only the required material will have to be redacted by the police. This would be done in line with the maximum time of service set out within the Better Case Management Handbook, January 2023, which states that service is required no less than 5 days before the hearing. So we must accept that there may be a slight delay in the CPS being able to serve their case on the defence at the point of charge. But the time in which it will take the police forces to apply for a charging decision to the CPS will be far quicker, without the need for redact, thus stopping defendants being on bail under release under investigation status for as long as they currently are, and victims of crime waiting less time for charging decisions. In addition, the Police Federation have highlighted that while auto-redaction software will help to mitigate the current issues, it will not recover all policing capacity in respect of redaction. Officers will still need to review the item to consider what auto-redaction parameters need applying. Otherwise, police could risk ending up with mass over-redaction and having to check to make sure nothing has been missed. The real benefit for auto-redaction software will come post-charge, especially if the CPS state exactly what material they intend to use or disclose. I also appreciate that the government feels it cannot support my amendment because of 3 technical legal points, and I would like to summarise the Police Federation's response to this based on advice from their own leading counsel, who are experienced in the field of data protection and privacy. The government's first objection is that there are provisions in the Data Protection Act 2018, other than the first and third data protection principles, that in effect require the material concerned to be reviewed and redacted. The 2 examples given by the Home Office were the 6th Data Protection Principle and Section 44 of the Data Protection Act 2018. The 6th Data Protection Principle, data security, does not require case files to be redacted. The same standard of appropriate technical or organisational measures will be required whether the case files are redacted before or after the CPS has made a charging decision. As to Section 44 of the Data Protection Act 2018, the Police Federation's leading counsel has pointed out that Section 44.4 already contains potentially relevant restrictions on a data subject's rights under Section 44. The restrictions on the data subject's rights during the investigation would be consistent with an amendment providing for the police to carry out the redaction exercise in relation to any given case file only after the CPS has decided to charge. So far, as the Home Office's second objection, that a broader amendment may be problematic for the ICO and international stakeholders is concerned, the legal experts have highlighted that the proposed clause only seeks to determine the respective responsibilities of the police and the CPS in relation to the processing involved in the preparation and submission of a case file to the CPS for a charging decision. It does not remove any substantive protection, nor does it remove the obligation to review and redact the personal data contained in material in a case file. Instead, it simply provides for such review and redaction by the police after, rather than before, a charging decision has been made. The Law Enforcement Directive, on which the relevant part of the Data Protection Act 2018 was based, would have permitted this when the Act was passed, and there is no legal reason why it cannot be introduced now, I'm told. As the Home Office's third objection, that other privacy laws might require the police to review and redact case files, even if the Data Protection Act 2018 was amended in the manner suggested by the Police Federation, the legal experts have pointed out that the data protection legislation does not generally seek to regulate other privacy protecting laws. The impact of the Data Protection Act 2018 on journalism provides a good example, as the journalism exemption in Schedule 2, Part 5 of the Act does not seek to regulate the common law tort of misuse of private information. the data protection legislation should be appropriately calibrated in a particular area, even if other legal rules may also have a role in the same area. At present, it is the data protection obligations which give rise to the problem, and is mere speculation, they believe, whether if those obligations were amended, other legal rules might give rise to a similar problem. It is crucial that we do everything we can to ease the administrative burdens on police officers so that we can free up thousands of policing hours and get police back onto the front line, supporting communities and tackling crime. My new clause would go a long way to achieving that by facilitating the free flow of personal data between the police and the CPS, which will speed up the criminal justice process and reduce the burden on the taxpayer, a stated aim of the government. How disheartening it must be for a police officer to take time and patience redacting data only to find that the case does not go forward. 25% of those cases are the same. Common sense must prevail. Thank you.
Sorry, Kate Osborne.